Hi, my name is Jofan. I'm 20 years old. I'm a law student, and I'm currently the intern of Gayatri Raman, the head of customer discovery and innovation, Asia LexisNexis. Now, my boss gave me this project with you in mind, hoping that through this short crash course, it will be able to add value to your daily work at LexisNexis and and you'll be able to understand how the law in which you're selling and dealing with every day, whether you are in the reception or you're working in the marketing or sales department or whatever you're doing in LexisNexis, that it will add value to what you do every single day. Now, I think I'll just go right into the course. First of all, to understand the law, you need to first understand what the functions of law are. Now, there are two functions of law. The first one is to maintain social cohesion, and the second one is to facilitate social progress. Now, what does social cohesion mean? Social cohesion generally just means that it means social harmony. It means that the society is intact, that there's no chaos, and it is harmony. So what does the law do to maintain social cohesion? There are 5 reasons that I've listed out in this VADR. The first one is the values of society. Now, how does the law do in maintaining the values of society? Now, you see, for example, in the US, in the 40s or 30s, there was no issue about equality. It was just normal that the white men were more dominant, and the black people are second-class citizens. But come the 60s, when Martin Luther King started the civil rights movement in the US, people realized that there were new values in society, that hey, now we need to fight for equality. We need to fight for amongst the whites and the blacks, and then there's new values in society. Like lately as well, we have the issues of same-sex marriage. That there is a new value in society, that the new rights that we need to protect, that was not there before. And the laws are here, to accommodate these new values of society that always emerges, so that nobody is left behind. Now, the second one is acceptable conduct. The law sets out what you can do, what you cannot do, and so that everybody will be in order. Like for companies or corporations, you have the Companies Act that sets out what they can do and what they cannot do. For people, or general people in society, you have things such as the Penal Code in India and Malaysia. That sets out what you can do and what you cannot do as people. What does it mean by killing people? Or what is too much? What is acceptable? So that people don't go over their limits. So the law sets acceptable conduct. Third one is dispute resolution mechanism. What this means is that it provides a platform to solve problems between individuals or between the government and individuals. Now, between individual, it's called civil law, in a sense where it's a dispute between one person and another person, such as when person A has spoiled the reputation of person B. So person B would sue person A for defamation or for ruining his reputation, and this is a dispute between two people, or probably even two corporations. This is civil law. For government individual, these are what we call criminal law. So when you kill somebody, or when there's people who rape somebody, it is not an offense against not just an offense against the person itself. The law sees it as an offense against the whole government, the whole country. So you see cases like PP against something, or Crown, or the R against something, or DPP against something. The PP actually means public prosecutor, so they represent the government, and they will be the one taking the case against you. That's how criminal law works. And then we have the fourth reason, I think, fourth reason: evolving society requires changing laws. Now, what the law does is like what I said just now. Over time, the society changes values, and there will be new standards of conduct, and there will be new rights, and there will be new problems that arise based on all this, and you need new methods to solve these problems. And the law accommodates for every level of all these things. So if there was no law, it will probably be in a very big mess. On the fine, the law provides a lot of rights of individuals and groups. So, what the law aims to do is to accommodate as many rights as possible, like civil rights, legal rights, property rights, digital rights, all these rights that we have here, so that nobody is left behind as well, and everybody is protected. Yeah. And the second function of law is that it facilitates social progress. Now, what does that mean? Well, when we say that the law facilitates social progress, what it means is that we bring forward social cohesion to the next generation. And how does it do that? The first one is that it makes and enforces law, and the second one is that it reforms law in response to changing value. And then we will see that and through all that, we are able to facilitate progress to the next generation in a stable manner, and that to keep the society in order. So that's what the law does. And now, what are the institutions that carry out these functions of law? The legislature, or some place in the Philippines we call it the Congress, or in Malaysia we call it Parliament. These are places where people make law, legislature. Second one is executive, whereby what it means is just the government, the cabinet, where you have the prime minister, president. These are people from the executive. They also carry out a part of functions of law. And the judiciary, the courts, they adjudicate or they listen to hear cases, they hear disputes, and they look at the law and they tell you what's right and what's wrong, whether you have breached the law or you have broken the law or not. These are three of the greatest, the main institution that carries out the functions of the law to move it forward, to progress it to the next generation through time. Okay, now we move on to the rule of law. Now, what is rule of law? You have always, looking in LexisNexis, you would have heard this over and over again. This is a very important philosophy of law. That is actually states that the very reason why laws exist. This guy, Thomas Fuller, he puts it very well when he says that be you ever so high, the law is above you. Now, this generally sums up what rule of law means. There are three general principles as well of the rule of law. I'll just go through very quickly. The first one is that no man is above the law. Very easy to understand. Second one, that no man can be punished unless they are in clear breach of law. So if you are breaking the law, then you must be punished. But if you don't break the law, you cannot be simply punished as well. Third one is about common law, which I will touch later. Now, to sum it up, what rule of law is that the law on top there is king, and everybody, whether you're individual, whether you're government, or whether you're a corporate company, you are equal before the law. Nobody is higher than anybody else, and that's why it is very, very important to have independent courts or independent judiciary, so that nobody will be biased against, and everybody, whether they are people or government or corporates, or corporations, if they are wrong, that means they are wrong. And that's why it's very important to be have an independent courts. Now, to further make you understand on what the rule of law is, the opposite of rule of law is the rule of men. Now, these three are famous dictators. You see Adolf Hitler, Kim Jong-il, and Robert Mugabe. These are dictators. They don't have law above them in their countries. So under their administration, they are the law. Whatever they say becomes law. So, they are never controlled by law. And that's why in these places, there generally no social cohesion and no social progress. And what happens there is that you will see underdevelopment, you see poverty, you see people's rights being denied. It's a just complete mess in those countries, and there will be corruption because they can just do anything they want based on anything they like without any law governing them. And that is the rule of man. That's why it is important to uphold the rule of law, to make sure that the law is enforced equally in every country in the world. Now we got to talk about the sources of law. Where does the law come from? Well, there are two sources of law. One is the primary sources of law, and the second one is secondary sources of law. Now we will start with the primary source of law, and the primary source of law has two as well. Parliament or the courts. The parliament makes laws, the courts also make laws. Now how they do that? Now we start with the parliament. What they make, we call it the statutory law or acts of parliament, or we just call them statutes. And how the parliament or the legislature normally make law is, it's normally like this. In the lower house, you have your members of parliament or ministers. They will propose a new law, or we call it a bill, and they'll go through readings and debates and amendments, and normally it'll be be very dramatic. And after that, if it is passed, you'll be going to the upper house, where the senators debate on the bill as well. So if it is rejected, it will be going back to the lower house, or it will be just thrown away completely. And if it is passed, it will be gazetted as law. So this bill or the draft becomes law. This is how acts of parliament comes about. The second one is common law, or we call it judge-made law or case law. You understand why they call judge-made law or case law very soon. Now, for case example 1, the Anti-Cats Act 2013 bans all people from keeping cats as pets. Let's say, this is for example, John is charged under the Anti-Cats Act 2013, but he argues that his pet is not a cat. So he's saying that based on the definitions of this act, I actually think, because the definitions of this act, it says that a cat has to have whiskers, has 4 legs and a tail, but hey, my cat does not have whiskers. So John argues that his pet is not a cat, and therefore he didn't break any law. So the judges would then need to look at the case and decide on how they interpret. So let's say this judge has decided that, okay, fine, your pet is not a cat, and therefore you are not in breach of the law, you don't go against any law, and you are free to go. Okay. And the next case comes, same issue, charge for keeping a cat. Same issue also, the cat does not have whiskers. The judge would then make the second judge would then make a decision based on the first judge decision, the interpretation that this pet that has no whiskers is not a cat, and therefore the second person will also be set free. So this the first judge's decision will be made as law, and this is called judge-made law. It's also case law. So yeah, that's one example of how case law works. The second example is I'll take murder for example. In Malaysia, we have the penal code. The penal code is a state act of parliament, like what we said just now. You remember what I talked about? Like it's made by parliament, went through the lower house and upper house, and it becomes law. It sets out what murder is and what's wrong, what you can do, what you cannot do. That's Malaysia. But in the UK, because they had these kind of things, they had judges before they had parliament. So way before, for example, Sir Edward Coke in 1797 defined what a murder is when he was going around, because at that time judges were going around UK or England, and they share with each other what their judgments are, and they refer to each other on their judgments, and sometimes they refer and then they enforce it as well. So this is Sir Edward Coke's definition, and that is still used until today. And you can see that even through time, like this term unlawful killing is defined by our Crown against Clegg. This word being is defined by the case in 1998. This word malice aforethought, or it means intention, is defined by all these 3 cases through time. And you can see from this that this law that talks about murder is developed through time, and it's not based on act of parliament, but it's based on decision of judges. So this is how common law works. This is how judge-made law works, and how it's made. Okay, now we move to the secondary sources of law. They're generally not made by courts or not made by parliament. These are people's opinions of what a law is. Law reviews. They have books about law, articles about law, legal reference books about law. These can be referred as well in court, but they are not as powerful as primary sources of law. And these are also provided by LexisNexis. Now, we go into the types of legal system. There are three types of legal system. We have the common law system, civil law system, and the mixed system. Now, the common law system is just like what I said just now. It's based on the principle that it's unfair to treat cases with similar facts differently. So it's just unfair. Like for example, just now the Anti-Cats Act. We have the first person coming in, and the pet that doesn't have whiskers. We set the guy free. But the second guy comes in, and his pet doesn't have whiskers too. But if the judge decides that, you are wrong, this is still a cat and you must go to jail, it's not fair, right? So that's why common law system is based on the fact that it is unfair. If you have cases with similar facts, then he has to be treated the same. And so the previous decisions, like what I said, binds future decisions, and if there are disagreements with whatever that is set in the case law, the higher courts can overlook it and make a new decision that all other courts will follow. So this is generally practiced in Commonwealth countries where the British used to colonize. So you have places like UK, Malaysia, Singapore, Hong Kong, India, Sri Lanka, Pakistan, and Maldives that practices the common law system. Now, the civil law system is very, very different, but it's generally practiced in majority countries of the world. It is based purely on a collection of written law. That means, and all the interpretations and principles and everything, they are all written and it's all done. And they refer to it by case-to-case basis because they think that every case is unique and has been looked differently. And the judges will read all these ready-made, all these made laws, all these on paper, and make their decisions accordingly without referring to previous cases. So countries in Asia that practice this civil law system are such as Indonesia, Thailand, China, Cambodia, Vietnam, Japan, and Korea. And then we move on to mixed systems. Mixed system is very rare, but we have one country in Asia that practices the mixed system, which is the Philippines. So in mixed system, what they normally do is that they will practice civil law in local and state courts. The lower courts, they will practice civil law. They will just make decisions case by case. But in federal courts or the higher courts, they will make decisions based on previous decisions based on common law. And we probably call this a fusion of the two systems. Now we move on to the last part of my presentation. How are laws used? I've identified 4 different parties that use the law: students, litigators, corporate lawyers, and in-house lawyers. Now the students use the law such as textbooks, law journals, statutes, and search engines. They need to use this for their studies, for their assignments, for their research, and their papers. And these things are all provided for by LexisNexis as well, through things like the CLP textbooks. We have our search engines and our law journals. Litigators are lawyers who goes to court. So what they do is normally they do the research when the case comes, and they need to do research based on statutes, based on commentaries and things like that. They will need to do research for their case. Then they'll cross-reference. Of course, they need to look at previous decisions. What the judges said previous time. What is the rules that are set in previous decisions. They need to cross-reference with law journals and with our Lexis and search engine. And then of course they will need to move on to understanding the procedure. So with the rules of court and all these things, they need to understand the procedure. If not, they will be really, really scolded by really angry judges because they do not know the procedures. So all these things as well, we do all those. You know them, you design them, you sold them. And then we have corporate lawyers. Corporate lawyers do not go to court, but they generally do things like they draft contracts, they draft agreements, they work on takeovers and mergers of companies, copyright, intellectual property, banks, and all these things. They provide legal advice to companies. So they don't go to court, but they work on all these things that are corporate. And we have all these resources that we have provided to all these corporate lawyers as well. Now we move on to in-house lawyers. In-house lawyers is very special, very different. They are employed by a company and to give legal advice to these companies. they're not under law firms, but they're employed by the company themselves. So they can't go to court, but they can manage litigation. What that means is that they do research, they work on the paperwork and things like that, and they will pass all these documents that they have to the litigator that the company employs, and they also mainly in fact provide legal advice based on the current development of laws. They work on they study things that corporate lawyers study as well, so that they would understand and give accurate advice to the companies that they work under. So LexisNexis as well, we provide all these things for them so that they keep up to date with the latest and most current development of the law. So we really help them as well. Even other than in-house lawyers, I also realized lately that we also provide services for governments and ministries and government agencies, and they use our services in their drafting of laws, in the drafting of policies, so that they can be they will do everything according to the law and according to the system that is already in place, and we provide these services to give them these informations that they need as well. So to sum up this whole thing, you realize that every single thing you have been selling, been designing, and been doing actually plays a very acts as a very significant puzzle in the whole big picture of uplifting the rule of law. Every small thing that you do in LexisNexis actually plays a big part in keeping this world in harmony, to maintaining social cohesion and to facilitate social progress. It's not just a routine you do every day, but you're impacting the society every day in everything you do. So I would just like to show my deepest and highest respect for all of you here, and I hope through this course you would have understood and realized how important your job is in LexisNexis, and that this course would have added value to what you do every day. Thank you. I hope this would be enough information for you, and that you understand more of how the law works. Thank you.